I'm thinking probably everyone is still giving the test because I see very few of you live on the app. So can we wait for some more time before we begin the discussion? Okay, wait कर जो, then we can begin the discussion. You can write your doubts or comments, whatever is there, you can post it in the comment box because there is no way to interact with me. So you can post it in the comment and we can take it from there. Okay, so people are finally joining in. How is the paper? Please write in the comment. How is the paper? Was it good? Was it tough? I gave a little more time. I should have given like 1 hour, but I thought probably it will be a little too much because it's the first time you're appearing this subjective test on an online mode. So I thought it is better. What is not opening, Pratiman? What is not opening? Can you not see me? Or is it not, the link is not visible? What is it? Okay. Anyway, I think most of them probably who have joined the exam, they have joined with us. What was the first question? The first question was from CPC. It directly was from order 39. So if I say how to approach it, it would be probably if you write the introduction, then you'll write the object of order 39, why order 39 was framed. Now after that you can write the meaning thereof, the meaning of the injunction and meaning of temporary injunction. Also write the kinds if you have kinds of injunction that we had discussed, and how CPC deals with temporary, and then you can discuss the grounds of temporary injunctions. को ground injunctions होते those things, right? Those are a must. That is, we had discussed probably seven grounds. Yes, someone has written La Abogada. She has written that questions were good, but I have writing issues. No issues. We'll address them together. This is the first exam. As I told you, exam is never something to measure your knowledge. It is just to put you under the pressure and see how you perform. Sir, the question was tough for me, but I could not manage the time as well to attend all questions. Okay, no issues, because I made sure it was a little problematic based, just to make sure that you are prepared for the tough questions that you can face, if any, that comes in the exam. 7 grounds I wrote, sir, but types of injunction I did not mention. That is fine. I said that was optional. Types of injunctions, that was optional if you get time only. So again, coming to the question, you must have so many things to cover in an answer. Can you please address how to write it in a concise manner? Yes. So as I told you, first you give the introduction. We go to question. Let's discuss order 39. So you first give the introduction, that what is an injunction and object thereof, that why injunction needed. Injunction is needed for this purpose. We had discussed the object, so you'll write that. Then you write the meaning if necessary, and then you come to the grounds, which section or which rule it was discussed, and then you come to the grounds of injunction, under which grounds an injunction can be passed, and then you come to the conditions straight away. If you have time, then you can probably discuss the Morgan Stanley case. Morgan Stanley case also you can discuss. I'm getting calls. Anyway, Morgan Stanley case, Morgan Stanley versus Karthik Das case, if you write the principles thereof, that would also be a little good. But make sure you divide it into, you divide the answers into time. You have to manage time. So what do you have to do is that questions, 1 hour 15 minutes, so 75 minutes, so roughly 80 minutes. So at max you can spare 20 minutes for a question. More than that you can't. So for short questions, 4 minutes each, and for long question 20 minutes in total. If you had divided, I don't think there would have been an issue. But if you did not do it, probably then it would have been a situation where you would have faced the time crunch. But if you had divided that, I don't think there would be a time crunch. Next, so the or question was, so the second part of the question was order 39 rule 3, that when an exemption can be granted, that was the question. So you must have written the generally it could be granted only when notice is given, but in exceptional circumstances only you can give injunction without serving notice. And what is that circumstance? You have to mention that. Yes, sorry sir, I have also same problem. I cannot attend all questions, Shrabani. No issues, Shrabani. This is the first time. I think in the offline exam that we will conduct next, probably the issues will be addressed. Now coming to the problems probably you must yes, that was the part 2, and the or question was constructive res judicata. That was explanation 4 of section 11. You all know the part 2 of explanation 1 to section 11, that is former suit. What is a former suit for the purpose of res judicata? So while dealing with constructive res judicata, you should have written the introduction, object, meaning of res judicata. You should have given something about res judicata. You can't come to constructive res judicata altogether just like that. You should have written res judicata first, and then from there you should have come to constructive res judicata. You should have given the concept of deemed res judicata, how it is a deemed res judicata, principle thereof, the object thereof, and how you could have also given an illustration that you could, in the answer you could have given an illustration saying that this is the ground of could have taken, but he did not take. You could have written that in a suit for suit claiming possession, he was A was challenged it on the ground of adverse possession, but he did not take the plea of owner. He took the plea of ownership. He could have taken the plea of mortgage also, but he did not do it. So it was a ground of attack he did not take. So it will be deemed as if he had taken it. So you could have given an example like that also. Then coming to the problems that those will be concerned with 2A. 2A is defendant had notice. First, those are the two conditions. That is, first is defendant had notice thereof, and the second condition is that he had sufficient time to appear. And in which rule or which order it is written? Order 9, rule 13. Order 9, 13, rule 13. If you had studied, it is a direct question from that. Then 2B, that is again directly from order 7, rule 11. That if it is undervalued, the court will ask it to value it correctly. If it still is not done like that, it will be rejected. Now 2C, in order 9, rule 2, that is if it is not done, then the court will dismiss the suit. Of course, if it is dismissed like that, then 4 says a fresh suit can be brought on the basis of that. So here a fresh suit can be brought. Now coming to the next question 2D, that is you know that written statement should only be filed within 30 days. It can be extended up to 90 days. So here he has accompanied it with a COVID certificate from COVID. He has some delay. We had studied that it is a mandatory provision, so it can be extended extended beyond 90 days as well. So in this case, it can be extended beyond 90 days as well. Now coming to the fifth question, that is fifth question again directly from section 20. Section 20 illustration, second illustration, if you have seen that, it is directly from that. Then coming to the questions of T question is section 6 directly. You have to write it. As I told you, always proceed the answer with an introduction and object and the meaning, and then you write the principles or ingredients. So here you could have written, generally a property of any kind can be transferred, but what kinds of property cannot be transferred? Those are given in section 6 of TP Act, and you could have mentioned those all those things that are there. Now the next part of the long question, that is section 38. That is section 38, I think. Ostensible owner. We all know, I feel that everyone must have, anyone who has attempted that question must have attended it correctly. Ostensible owner, section 38. You have to write what is an ostensible owner. So a property, normally only a person having absolute ownership over that he can transfer it, but in limited cases a person having limited ownership can also transfer. And so in that way, all the ingredients that are there to be satisfied for ostensible owner to happen, so you could have written that. And then the second part of the question is that what is the right of a bona fide who is in distress if he gets such a transfer which has been transferred by an ostensible owner. So that is again there in 38 itself. You directly write what are the rights that he has, that if it is transferred, and saying a condition that the existing condition was there and now it is not there, so you can probably get it. Again, anyone has any doubt? Anyone has any doubt? I believe it was section this question 41, and we had not discussed it. Probably that must be an issue. Nevertheless, it was asked like that. So I hope all of you have answered it correctly. If not, also it is not an issue. Then coming to the problems part, that is 2A, that is what are the conditions which cannot be imposed. It is a direct question again, that is section 25. Yes, section 41, and we had not studied section 41, so probably some of us must have missed out. I wrongly said that section 38, it is section 41 itself. Now coming to 2B, that is under what circumstance a person required to elect under the provisions of TP Act is deemed to have accepted the benefit. So there was 3 conditions, that if it is he has kept it for 2 years without informing, then it is deemed to be accepted. If he has kept it for 1 year and when he is given a notice he does not do it, then, and then another is if he exhausts it and he does something in order to make it not usable any further, then in that case also it is deemed to be accepted. Now coming to the third question, that is again directly section 6, chance of an heir apparent succeeding to an estate, whether that can be transferred. Section 6 says no. If you had TP Act's first question, that is section 6, probably you would have answered this as well. Now D, Daya transfers his farm at Mirzapur to Hiralal if the sun sets in the west, and with further condition that in the event Lufthansa flight number Ethical lands before 7:55 am at Frankfurt, such property shall be transferred to Aditya. What are the kinds of interests Hiralal and Aditya have over the property? That is One is vested interest, that is when sun sets in the east, that is vested interest. But now he is imposing a condition which may happen, which may not happen, so it will be contingent interest. Then coming to the last question, that is George transfers his mansion at Maldives to Francis for life and then to his unborn son on him attaining 23 years. It is again section 13 and 14 direct interpretation, so it can be transferred only uh, till the lifetime of the life interest holders plus 18 years. Now here it is transferred to 23 years onwards, so that's why it will not be valid. Yes, probably we messed up in the question while framing that. We asked ostensible owner. It is section 41, but nevertheless, the second part of the question is probably from section 38 itself, but the concept of ostensible owner was asked. So I hope all of you have probably attempted the other question, that is define immovable property and what are the kinds of properties that cannot be transferred. So immovable property we all had discussed. Clauses Act, in that it is given what are properties which are called immovable property, which properties are not properties. Those are given in uh, will it be valid till the lifetime of Francis? Will it be valid? See, now when he is imposing a condition that it will be transferred to Francis for life and then to this other person, unborn person, to his unborn son on him attaining 23 years, it will not be a valid transfer, because you can't keep the property in abeyance for long. That the if you violate the provision in section 13 and 14, and if you keep it uh, beyond that period, then it will not be a valid transfer. So it will not even be valid for that period, and it will be in fact an invalid transfer, because you are breaking the rule that is given in section 13 and section 14. Anyone has any other doubt? CPC was relatively easy, don't you think? CPC was relatively easy. Anyone has any uh, comment to make? Yes, Asif, yes, section 41 also speaks about bona fide owner, but bona fide owner and bona fide transferee who gets it like that. But then this question was meant to be asked from section 38. Nevertheless, it is asked. I had kept in mind that I'll ask question from section 38 only, but somehow section 41 has been asked. Probably I did not double check it. That's the reason such a mess happened. Nevertheless, section 6 was there, so I'm sure all of you must have attended the easier one, that is immovable property and section 6. What else? Does anyone know how to like write the answer, in what form it should be written? Okay, if it is like that, we can just, I'll tell you what in order 39. I mean the first question, introduction would be very simple. That is, you write that this is injunction is when the civil court is trying to protect the property the interim period when the suit is still to be disposed, thinking that uh, it might be at stake or it might be sold off by the defendant. In that process, the plaintiff's right will be hampered, and that's why in the meantime, if there is any order passed directing a person to do or not to do something, that is an injunction. Then object thereof is obviously to protect the suit property. Meaning of injunction, that is again, as I told you, to do or not to do something. Then the first part of the question, let me, yes, first part of the question asks what is the first part of the question? First part of the question was that in which case the court can grant a temporary injunction. So in which cases, straight away the 7 grounds that are there, we had discussed all the 7 grounds, you write those 7 grounds then. Then what are the prerequisites for passing an order of in fact, while discussing the grounds, you also write the principles. The prima facie case, irreparable loss, right? The balance of inconvenience, bona fide uh, person coming to the court, all this you write. Along with that, you write the Morgan Stanley versus Kartik Das case, the principles that were given, 7 principles that were given in that case also, you'll write. Hardly it will take all this to write. I think 15 minutes this answer could have been written very well, and then you could have wrote the second part, that is order 39 rule 3, which speaks of only a certain thing, that in normal cases it should be the rule that the person concerned must be, the opposite party must have a notice before an injunction is issued against him, but ex parte injunctions can be issued. It will defeat the whole purpose. So in that case, you may pass an ex parte interim injunction along with the of order 39. So you should have written that you have to satisfy the order 39 rule 1 and 2's condition, and then as a special measure you also have to satisfy the order 39 rule 3's condition, that is